Hello everyone. The usual housekeeping to start. As I'm sure we all know by now, please can you ensure your microphone is muted and your video is off. There is no fire alarm scheduled this afternoon, so if you hear one, unmute your microphone and shout at me to leave my house. My toilet is over there. You'll know where yours is, but whatever you do, do not take your laptop into the toilet with you. Not a good look. Those are the preliminaries, so let us get underway. Good afternoon, everyone, and thank you for zooming in for the third in a series of webinars by the Product Liability team at 2TG. Isabel Barter and Alistair Mackenzie got the series underway on 8th April, with Charles Docherty QC delivering the second webinar on 23rd of April. If you missed these very informative presentations, then they're still available to view on the 2TG website. I commend them to you. My name is Vinit Khurana, and I am one of the newer members of Chambers, having joined in November last year. I'm told my accent gives away where I spent my formative years. In fact, I grew up near California. Unfortunately for me, that's the former pit village of California, about halfway between Edinburgh and Glasgow. For those of you who don't know me, I qualified in medicine in 1988. I spent about 4 years working in various hospital posts, including A&E, Obs and Gynae, Pediatrics, ENT, Ophthalmology, various other specialities before becoming a GP. I worked as a GP for about 12 years, but combined it with doing a law degree and then calling to the bar in Scotland in 1999. I took silk in Scotland in 2018. And coming from an Asian background with medical parents, medicine was up here, and law maybe not so. They also brought me up to believe that you pay for the sins of your previous life in your current life. I suspect in their eyes, I must have done something pretty bad in a previous life to move down the food chain from medicine to law. Today, I'm going to give a roughly 15-minute presentation on the learned intermediary rule insofar as it relates to the duty to warn of risks associated with medicinal products. It's an area I find fascinating, and the theme I'll develop is how the learned intermediary rule interplays with the ruling on informed consent in Montgomery. I'm conscious that not everyone listening will necessarily work in both product liability and clinical negligence fields. So I'm happy to discuss any of the issues I raised today in more detail at a future date. Please do let me know if you have any questions or if you want me to do a webinar for your team where it can be a bit more interactive. For today's purposes, feel free to ask questions by the chat function, and that applies to both my talk and that of Sam Stevens after me. My plan for today is to divide the talk into 3 sections. Firstly, I will briefly set out the legal framework, both at common law and under statute. Secondly, I will look at some cases which help to focus the interesting interplay between product liability and informed consent. And finally, I will explore some of the issues to illustrate where case law may develop in the UK in the future. Turning to the first of these, the legal framework. At common law, since the 1932 case of the Paisley snail, unknowingly marinated in ginger beer, otherwise known as Donoghue and Stevenson, manufacturers are required to take reasonable care to ensure that consumers are not injured by their products. Part of that duty includes providing any relevant warnings associated with the product. The warning has to be provided by the manufacturer to the ultimate user of the product, hence the requirement for documentation usually supplied within the product packaging. And that's often called instructions for use, or IFU for short. The learned intermediary rule applies where a product is only intended to be used under the supervision of experts. And in this case, we're talking about doctors. So the manufacturer discharges its duty to warn consumers by giving full disclosure of risk to doctors. It's then up to the doctor to pass on to the patient the information they feel is relevant using their professional judgment. A doctor's duty in relation to passing on of risks is now governed by Montgomery and Lanarkshire Health Board, a Supreme Court decision of 2015. Now Montgomery, I won't go over the facts of Montgomery. I'm sure you all know it's related to it's an obstetric case related to the delivery of a baby who was born, unfortunately, with shoulder dystocia, the shoulder being stuck in the birth canal. And it involved an injury to the baby, although fortunately he was born alive. The test in Montgomery is that the doctor is under a duty of care to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And the test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. Now, another aspect of Montgomery that's quite interesting for our purposes is in paragraph 90 of the decision. What the Supreme Court stressed is that the doctor's advisory role involves dialogue, the aim of which is to ensure that the patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives, so that she is then in a position to make an informed decision. This role will only be performed effectively if the information provided is comprehensible. And my emphasis here, the doctor's duty is not therefore fulfilled by bombarding the patient with technical information, which she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. So I'll come back to that theme of not bombarding people with information, with technical information. So that's the common law position. What's the position in statutory law? Well, as you know, the Consumer Protection Act provides a remedy where damage has been caused by a defect in a product, and that's via Section 2.1 of the 1987 Act. Here is how the duty to warn is arrived at through the statutory route. Section 3.1 provides that a product is defective if the safety of the product is not such as persons generally are entitled to expect. And Section 3.2 provides that all the circumstances shall be taken into account when determining what persons generally are entitled to expect, including any instructions for or warnings with respect to the product. So an IFU that fails to warn of a relevant risk means the product is defective. Under statute, there is strict liability, being focused on safety rather than the fault of the manufacturer. So that's the law. Moving on to the second of the three parts of my talk. Let us now turn to look at the case law. Thus far, there have been very few UK decisions in relation to learned intermediaries. The two recent Depew cases, Wilkes and Gee, both to do with hip implants, have confirmed the presence of a learned intermediary to be a relevant factor. However, presence alone of a learned intermediary is not automatically determinative of the issue. In Gee, it was stated thus at paragraph 169. I apologise for the detail of this slide. But the weight to be given to the existence of a learned intermediary and the information, including warnings, passed on to such intermediary, evaluation of whether the product met the entitled expectation of safety, will depend on the circumstances of the individual case. In assessing safety, the focus must be on what the public generally are entitled to expect, not what clinicians are entitled to expect, but the latter may have a considerable bearing on the former. Where a product is not defective, the regime is not designed to classify it as defective because of some fault or failing on the part of the intermediary. For example, a failure to pass on warnings or obtain properly informed consent. That reference to informed consent at the end of this extract is interesting. Prior to the decision in Montgomery, some commentators had expressed concern that claimants may fall foul of a potential lacuna in the law. A manufacturer may have warned doctors of a particular risk in relation to a prescription drug, for example, but doctors may not have invariably warned the patient about that risk. So the injured claimant's case against the manufacturer will fail because of the warning to the learned intermediary. And in addition, the claimant's case against the doctor would have failed because of Bolam, on the basis that the failure to warn of that particular risk was consistent with a body of responsible opinion. Montgomery, by disapproving of medical paternalism and thereby rejecting Bolam in relation to consent cases, has filled that potential lacuna. However, in doing so, it may have opened up some interesting arguments in relation to whether it is appropriate to rely on the learned intermediary rule at all. In other words, is the learned intermediary rule also paternalistic? And if so, is it outdated? In considering this, it's useful to have a look at some comparative law. Both America and Canada have had their equivalent of Montgomery from around the early 1980s. So they are interesting jurisdictions to see where the law on product liability has developed after the fall of medical paternalism. And what we can see in these jurisdictions is initially there's two ends of a spectrum in relation to the learned intermediary rule. At one end lie the over-the-counter drugs and shop-bought medicinal products. In that situation, the manufacturer discharges its duty to warn by providing warnings directly to consumers by way of IFUs on or in the packaging. And the English case of Worsley and Tambrands Limited of 2000 makes this point insofar as the risk of toxic shock syndrome applies to the use of tampons. And one can see why that might be. Consumers are choosing and buying medicinal products directly from retailers with no intermediary, learned or otherwise, advising them. One interesting thing about this is that there is no apparent regard for the health literacy of the consumer purchaser. And what I mean by this is that there are studies showing that health literacy amongst the population is highly variable. One study revealed that about 24% of adults in England and Wales, on reading the IFU for Calpol, could not correctly identify what dose of paracetamol they should give to their children. So despite the arguably adequate warning, the desired result is not being achieved. However, remember what the Supreme Court in Montgomery said, that the doctor's role will only be performed effectively if the information provided is comprehensible. So arguably there's a difference between the IFU, the learned intermediary disclosure, and that by a doctor to a patient. Anecdotally, I can tell you when I was a GP, an incredibly high proportion of problems were encountered due to patients' misunderstanding of the dosage of the drugs they were taking, prescribed or otherwise. And one of the first things you had to do when faced with any clinical presentation was to take a detailed drug history, including what drugs they were taking over the counter and prescribed, and what dosage they were taking them in. So coming back to the initial spectrum I was talking about, at one end you have the over-the-counter drugs, and I talked about the case of Worsley, and at the other end of that spectrum are prescription-only drugs and surgical implants, such as prosthetic hip joints, and breast implants. And in such cases, courts have held that the learned intermediary rule applies. So there's no duty to warn the consumer directly. The manufacturer discharges its duty to warn via IFUs to doctors. And again, one can understand the logic of this position, as generally, patients in these situations do not buy the products and rely on their doctors to decide the most appropriate drug or implant. However, an important consideration is that whilst they rely on their doctors, it's implicit that they expect the doctors to be choosing products in their best interests. This raises another interesting issue, which I will discuss in the final section of my talk. What factors are actually involved in a doctor's decision-making in relation to, for example, hip implants? And are patients aware of these factors? So that's the broad picture initially. Over-the-counter products, instructions directly to the consumers. Prescription drugs and implants, IFUs to the learned intermediary. However, as time progresses in these jurisdictions, one sees some subtle changes emerging. The oral contraceptive pill is an interesting example. It's moved from falling within the learned intermediary rule as a prescription drug to now requiring manufacturers to warn consumers directly of the risks associated with the pill. In Buchan and Ortho Pharmaceuticals Canada Limited, a case of 1986, the claimant suffered a stroke caused by the pill. The manufacturer, despite knowledge of the risk of the stroke by its sister company in another jurisdiction in America, failed to warn doctors of this risk in Canada. It also failed to put the warning in the patient information leaflet found within the packaging of the drug. The court ruled the manufacturer could not evade its duty to warn by seeking to rely on the learned intermediary rule. This comment was made in the judgment. Appropriate warnings conveying reasonable notice of the nature, gravity, and likelihood of known or knowable side effects, and advising the consumer to seek further explanation from her doctor or of any information of concern to her, would promote the desirable objective of ensuring that women are fully apprised of the information needed to balance the benefits and risks of this form of birth control, and to make informed and intelligent decisions in consultation with their doctors. Now that is language that is reminiscent of Montgomery. So there's a clear movement pushing patient autonomy ever further forward. The American case of Hill and Searle Laboratories of around 1989 came to the same result in relation to an intrauterine contraceptive device, or IUCD. So the spectrum is no longer easily divided by the category of product. Both prescription-only contraceptive pills and an invasive product, such as an IUCD, were viewed in the same way as over-the-counter medical products. And the reasoning of the court was interesting. It included the following factors. The physician makes the decision of whether a particular treatment is necessary or desirable. The patient then makes an independent decision which method of birth control she prefers, with only limited input from the prescribing physician. Now, those of you who know Montgomery well will recognize that as the two-stage test in Montgomery. So there's an initial decision about what's appropriate in terms of treatment choices, and then it's the patient that makes the decision. And that's echoed further in the reasoning of this case from America. The patient is the decision maker, and the patient choice is based on matters other than medical necessity, such as effectiveness and convenience. And again, that's reminiscent of Montgomery. The manufacturer marketed the product with the idea of convincing women to choose their product. So there was a marketing campaign aimed at the public, and it was feasible to warn consumers directly. So those are the factors, and we'll come back to some of these in the third part of my talk, that courts have relied upon in other jurisdictions to make a decision as to whether it's appropriate for the warning to go direct to the consumer or only to the learned intermediary. However, despite this, some surgical products have not yet, and I emphasize yet, gone down this route. The court in Hollis and Dow Corning Corporation in 1995 ruled that the learned intermediary rule applied, and there was no duty to warn the consumer directly in relation to breast implants. And the factors the court identified were that neither the product nor its packaging was aimed directly at the ultimate consumer, and it would not be feasible to warn that consumer directly. However, as I will now explore, I do wonder whether in the modern world, 25 years after this decision, whether those factors will still continue to be viewed in the same way. That brings me to the third and final part of my talk. What lessons can be learned from the experience of these jurisdictions for the future of our jurisdiction? The failure to warn patients about all material risks associated with a particular treatment is now in law deemed to be unacceptable to society. It is associated with the outdated concept of medical paternalism. However well-intentioned, paternalism should not overcome a patient's right to autonomy in decision-making. Claimants, and possibly co-defendant doctors and the NHS, may seek to extend the scope of that right to autonomy to include manufacturers of medicinal products. Claimants will argue that one of the main drivers of the learned intermediary rule is in fact paternalism. Under the rule, patients are deemed not to be capable of understanding risks without assistance from experts, and that's at odds with modern thinking on patient autonomy. One of the learning points from other jurisdictions is not to categorize products as to whether they can be bought over the counter or prescribed. For example, more and more drugs are becoming available over the counter, yet those drugs have the same or similar risk profiles to prescription-only drugs. An example is non-steroidal anti-inflammatory drugs, NSAIDs. Ibuprofen, one such drug, is available to buy over the counter without any medical input. Newer non-steroidals, such as Celebrex or Vioxx, which have an almost identical side effect profile, are only available via prescriptions. Why should there be a distinction between those two when the IFUs or patient information leaflets will be virtually identical? Defendants will want to make the point that IFUs for learned intermediaries perform an entirely different function to the IFUs or patient information leaflets provided for consumers in drug packaging. The former, the IFU, bombards professionals, learned intermediaries, with technical information. Think of it like the terms and conditions we all click on to agree that we've read online for Apple or Google. Clearly a blatant lie, we don't read them. It's simply small print fulfilling a legal obligation. And in the case of Hastings, a Scottish case recently, Lord Tyre pretty much came to the same conclusion in relation to IFUs for prosthetic hip joints. And remember the wording in Montgomery, no bombarding of patients with technical information. Well, should IFUs not be capable of being put into more user-friendly, readable and understandable format? Something to think about. Claimants may also argue that with technological advances in communication, it should always be feasible for manufacturers to relay information to the ultimate consumer. And the response by manufacturers is, how can they communicate with patients as they do not know who will be recommended their product by the doctor? But if you're acting for a claimant, you may wish to consider two responses to that. Firstly, the internet has made information more widely accessible than ever before. A patient can be directed towards a manufacturer's webpage detailing risks associated with the product. So it's very easy for the manufacturer to put the information out there, and it's very easy for the patient to access that information. In many cases, manufacturers already produce patient-directed brochures for doctors to hand out to those patients. So another factor to bear in mind is to go behind the decision-making of the doctor if you're acting for the claimant, and look for what's available. The doctor may actually only have one product available, and is it necessary to tell the patient that if they're going to recommend that product? Time is against us, and as I said at the outset, because of these time restrictions, I've simply highlighted some issues which I find fascinating. Clearly, the story is a lot more complex, and I've also not considered causation, which is often a very difficult hurdle to overcome for claimants. There are other statutory requirements imposed by regulatory bodies in relation to medicinal products. I'm going to leave you with this. We live in interesting times, and this is how one of my neighbours has been coping with lockdown. This was last holiday weekend. He apparently got a lot of stick on Facebook for this, so decided to pretend that he was simply using his boat as a ladder to paint and clean his windows. What I would recommend is comedy. I've stopped listening to the news. If you've not watched the BBC One Ronnie Blackberry sketch, then I would urge you to do so. On that note, I will pass you on to Sam for the second part of this presentation. Thank you for listening.
Yes, thank you. I will be covering the scope of Part 1 of the Consumer Protection Act. And in doing so, I will first look at the basics of who can sue and who can be sued under Part 1, but also just trying to tease out some of the difficult issues that arise in considering that. The question is, why is that important? Well, firstly, it's self-evidently important to know the scope of Part 1 itself for a matter of defending or bringing claims under that part. But it's also important because of a recent decision in the case of Wilson and Beco Limited. And in that case, it affirmed that Part 1 is part of an exclusive regime of strict liability for products pursuant to the relevant directive. And that where a claim can be brought within the scope of Part 1 of the CPA, other strict liability actions, for example, under Part 2, cannot be brought for that same damage. And so knowing the scope can act both as the source of the cause of action for Part 1, but also a potential defence for any claims brought under Part 2. Let's first turn to look at who can bring a claim. Well, the potential claimants, surprisingly, don't need to be drawn by reference to a definition of consumer. One looks at the type of damage, and anyone can bring a claim for personal injury where that is caused by a defect in a product. And it doesn't matter if that has been caused in the course of business or otherwise. The only real time that vague definitions of consumer comes in is in relation to damage to property. And there, damage to property can only be brought under Part 1, where in broad terms, the property that's been damaged is of consumer use, non-commercial use. And the definition of it is there on the slide. There are also certain restrictions in respect of the amount of property damage, so the claims have to be over £275, and the fact that damage can't be recovered for damage to the thing itself. There is far more to discuss, though, in relation to the potential defendants. And I've put on the slide there the summary of who could be sued. Firstly, there are the three, what I call primary defendants. That is the producer of the product, the deemed producer of the product, or in other words, someone who holds themselves out as the manufacturer, and the importer of the product. Where it's not possible to identify any of those primary defendants, there is a reserve liability against suppliers, and that will cover in some detail the circumstances in which a claim can be brought against the supplier. Well, starting with the definition of producer, that is easy to define under the Act, but in truth, in practice, it might not be an easy person to identify. In respect of products that are manufactured, then the manufacturer is the producer. Similarly, products such as raw materials that are won or abstracted, it's the person that does that, abstracts them, for example, that is the producer. There is an interesting final provision there on the slide, which is where a person is a producer if they carry out an industrial or other process which gives the essential characteristics to a product. So the best example of this is in the case of a National Blood Authority, the well-known case. And in that case, the National Blood Authority conceded that it was the producer of blood products which were given to patients. And the reason for that concession was on the basis that they processed the blood, tested it and packaged it, etc. There is a difficult issue here as to the extent of the definition of other process. It can be quite vague. One could question whether it extends to allowing a product, say, to age. For example, if one allows simply whiskey to age in a barrel while not actually doing anything active to it, would that be sufficient to trigger the process, or to trigger liability, sorry? But in most cases, as I say, producer in a manufacturing sense will be easy to define. There's much more interest or interesting issues when one considers the deemed producer. Now, under the Act, there are essentially two conditions to liability for a deemed producer. The first is that the defendant put their name on the product or use a trademark or other distinguishing mark in relation to it. And the second is that when doing that, the defendant held themselves out as the producer of the product. Now, I haven't been able to find any reported cases that deal with the issue of whether someone is a deemed producer. People often refer to the Court of Appeal authority of Pollard and Tesco stores, but that didn't actually consider it as a live issue. It had been conceded. The key issue under both the directive and the Act is to, in my view, to look at whether the person or the defendant is holding themselves out as the manufacturer of the product. And that will be a fact-sensitive exercise. But there are potential conflicts, which are interesting, between what one could take into account when one looks at the directive and the Act. The Act refers to, as I've said, using a trademark or other distinguishing mark in relation to a product. Now, that could, in my view, be taken to mean advertising material or marketing material that isn't itself part of the product. However, the directive states that liability will apply where the person puts their name, trademark, or other distinguishing mark on the product. And the relevant recital refers to affixing the name, etc. Now, that language doesn't sit easily with the idea of broader advertising being relevant to the question of whether or not someone is a deemed producer. Another interesting issue is the extent to which a person needs to hold themselves out, or what it takes to be deemed as holding themselves out as a producer. I think it would be sufficient for a person to put permanently on the packaging of a product the company logo or the company name, and that product doesn't refer to any other manufacturer. Equally, it probably won't be sufficient simply to put a sticker on an unbroken external packaging, particularly if that sticker is simply displaying the price. But there are numerous shades of grey. For example, consider a group of companies who are operating through Europe. The parent company, as the manufacturer, sends the product to its distributor in a different country, and the distributor simply puts on a sticker which has the entire group's generic branding. It's interesting to consider whether that, in those circumstances, the distributor would be sufficiently holding itself out as a manufacturer to have a claim brought against it. But in those circumstances, it's probably wise for the claimant to look to use the supplier method of liability to either identify the real producer or to go against the distributor themselves. And we'll come to that in more detail shortly. Turning then to the importer, presently any person who imports into the member states from outside the member states of the EU will be liable as a producer. But this is clearly going to be subject to change as a result of the UK leaving the European Union. And the current proposal, or at least what the amendment will currently be as things stand, is that the person who imports into the United Kingdom will be liable as a producer, which clearly hugely expands the scope of liability for UK-based businesses. Now, at present, there are no transitional provisions other than to say that the amendment doesn't make retrospective provision. But there's no guidance given on what is the relevant date for the purposes of retrospectivity. And so it's a bit of an open question at the minute as to what that means. And anyone who's interested in these amendments, I would strongly recommend looking at Alistair's earlier presentation, which is still available on the 2TG website. So those were the three primary defendants, but what happens where the claimant simply doesn't know who they are? Well, in those circumstances, there is a reserve liability against suppliers, which allows them to sue the supplier if the supplier cannot identify a primary defendant, or at least the person who supplied it with the product. The meaning of supply is very widely defined under the Act, and in broad terms, it will cover most transfers of goods. There are two prime exceptions which can be very quickly summarised. The first is an exception for finance companies that formally transfer goods pursuant to regulated credit agreements. And the second is certain contracts for chartering of vessels or aircraft or renting cars. I'm not going to deal with those in any detail because they're quite niche and specific. Safe to say it is doubtful as to whether they are compliant with the directive, because those are not found, those exclusions are not found within the directive itself. One important distinction is to distinguish between goods being supplied and goods being used when providing a service. The latter doesn't form part of the Act, or at least the scope of liability. And this was the outcome of the decision of the CJEU in the Dutroux case. And in that case, a patient at a hospital was undergoing surgery and they were on a bed which was heated, but the bed was defective and caused the patient, I think, quite severe burns. And the question was whether the hospital was a supplier under the Act. And the court held it wasn't a supplier because it wasn't covered by the directive either, because the hospital wasn't supplying the bed to be used, it was using it when providing a service. Now, there can be some unusual results of that because, for example, a plumber can go onto a site and wouldn't be liable for any personal injury arising from their use of one of their tools, which turns out to be defective. But maybe if on the same site they provided one of their tools to another person to use, another independent contractor. So yeah, there's some unusual results with that definition. But for the avoidance of doubt, if a service provider uses a product it has created in providing a service, then it will simply be liable as a primary producer, and the supplier issue doesn't really come into the analysis. So what are the conditions to a supplier being liable? Well, I've summarised them on the slide, but under the CPA, they can be broadly boiled down to this. First, the claimant needs to make a request from any supplier to identify one of the primary defendants. And that request must be made within a reasonable period of time after the damage has occurred, and at a time when it's not reasonably practicable for the claimant to know the identity of the primary defendant. The ball is then in the supplier's court, and to avoid liability, they have to either comply with the request or tell the claimant who supplied it with the product. Now, the interesting thing about that quite prescriptive set of rules under the Act is that it is in conflict to what is said in the directive. I've put the three, I suppose, key conflicts on the slide, but really this all stems from the fact that the CPA requires the claimant to make a request of the supplier, and that isn't found in the directive. In fact, the CJEU have gone the other way, really, and said where a supplier is faced with a claim, they need to identify the relevant primary defendant or its own supplier promptly and on its own initiative. There's no need for the request. So there's a bit of a lacuna here on how to interpret the CPA consistently with the directive. But in practical terms, claimants will be well advised to follow this procedure under the CPA to avoid these arguments down the line if it is the supplier that the claimant is going after. Equally, where possible, to avoid liability, suppliers be very well advised, if they know, to say to a claimant on its own initiative who the producer or importer of a product is, or who supplied it with that product. So that is the scope of the CPA, and it can be summarised as follows. The CPA and the directive essentially covers personal injury and death claims, and also for damage to other consumer property over £275. And it provides and defines the strict liability regime for products insofar as it applies to producers, deemed producers, importers, and suppliers. Now, the CJEU have consistently held that no other system of law can cover the same scope as the directive. It aims for complete harmonisation of the laws on strict liability. Now, in respect of liability for products, the only other schemes that member states can introduce are, firstly, contractual liabilities. So, for example, implied term as to goods being of satisfactory quality. Non-contractual liability other than strict liability. So, classic example would be negligence. Or pre-existing special schemes of liability which were in place at the time the directive was notified, which arguably has a special definition. And this position was confirmed in the case of Wilson and Beco Limited. And now Isabel discussed this in a previous talk, which I'd recommend reviewing. It's still on the 2TG website, but I've summarised the principles earlier. Essentially, if the claim can be brought under Part 1 of the Act, that means it's exclusively within the directive, and claims under Part 2 cannot be pursued against that supplier. So, as I said, there are numerous instances of strict liability regimes where the supplier may be liable for a product. But following Wilson, and most importantly in respect to Part 2 of the CPA, those cannot apply to personal injury claims, claims for a death, or claims for what's been described as consumer property. Now, this, importantly, would be so even if the supplier couldn't be sued under Part 1 of the Act. That is essentially the upshot of the Scot case, which I've cited there. Now, in that case, the CJEU held that a Danish law that imposed liability on a supplier where the producer was known was inconsistent with the directive. Not only was it inconsistent with the directive, but the directive precluded that as a base of liability. A supplier's liability in strict liability terms for products can only be determined according to the directive. However, the extent to which this, the distinction between Part 1 and Part 2 will remain effective is open to question. Wilson is currently subject to an appeal, but perhaps more fundamentally, the judge in Wilson relied or based his decision on the leasing principle to interpret the CPA in accordance with the directive. and didn't base it on ordinary canons of statutory construction. So once the UK leaves the EU, it may be that this issue will be revisited, given the questionable importance of the Marleasing principle, which we'll have to see in due course. So for present purposes, though, what we can say is this, that the scope of Part 1 of the CPA both sets out the boundaries for strict liability for products, but it is also can be a defence to claims as other modes of strict liability where the claim is brought under Part 2. Well, thank you very much for your time and listening to that. I will now hand over to Vinit.
Thank you, Sam, for that very interesting talk. We do hope you found today's presentations useful. If you do want to get in touch, please do so via the 2TG website, via the clerks. And if you want to watch any of the presentations in the series again, they're available on the site. If you have any suggestions for future talks by the Product Liability team, then please do not hesitate to get in touch. Thank you once again for listening, and do have an enjoyable weekend.